Am I audible?
Yes, you are audible. Am I audible? KRC
Yes, sir.
Ans Verma.
Hello, can you see the screen? And am I audible?
Yes, sir. So we'll be starting in just 3 minutes. Just in 3 minutes we'll be starting.
Screen share, I'm just stopping for the time being.
Okay, sir.
Am I audible, sir?
Yes. Once we'll start in 2 minutes, just wait for 2 minutes more.
Sure, sir.
Then we'll start.
Good afternoon, sir.
Good afternoon.
Sir, we'll just start with the session in just a minute. Just in a minute, we'll just start with the session.
No problem.
Okay, yes. Welcome, sir. So, Priyanshi, can you start?
Yes.
Yeah.
ॐ सहनावतु सहनो भुनक्तु सह वीर्यं कर्वावहै तेजस्विनावधीतमस्तु मा विद्विषावहै ॐ शान्तिः शान्तिः शान्तिः. May He protect us, may He nourish us, may we work together with great strength, may our learning be radiant, and may there be no discord between us. With this prayer in mind, from Ved Upanishad, we begin the second day of our journey, Saamanjasya. Yesterday, we stepped into Prastavna, the introduction to arbitration. The key takeaway points of the session given by Advocate Shaurya Krishna Sir included the historical background of how Panchayati Raj system in India and internationally, the New York Convention first recognized arbitration, and then the Arbitration and Conciliation Act came into force. We further debunked many myths relating to arbitration, including the efficiency of arbitration, the cost effectiveness, enforceability, and the global prospects of the same. Today, we move forward to further parts.
Just as a gatekeeper decides who may enter in arbitration too, questions arise. Who decides what? The arbitrator, the parties, or the institution? These are the subtle thresholds that shape justice outside the courts. We are fortunate to be guided by the vision and encouragement of our Dean and Principal, Dr. Ujjwala Bindale ma'am, our Vice Principal, Dr. Jyoti Dharam ma'am, and our IQAC Coordinator, Dr. Vidya Dhirya ma'am. We are equally grateful to our respected professors, Dr. Rohit Survase sir and Mr. Shubham Tripathi sir, whose dedication has made this program possible. On behalf of the Saamanjasya team, I extend my warm welcome to our distinguished speaker, Mr. Ashish Philip Abraham sir, Executive Partner, Lakshmi Kumaran and Sridharan, whose distinguished career brings invaluable experience and wisdom. We look forward to his insights in today's session. May today's discussion not only open the gates of knowledge, but also enables us to understand the role of these gatekeepers in arbitration with clarity and depth. Over to you, sir.
Thanks, and thanks to the team. Something. I'll just take a minute to share the screen. Is the screen visible?
Yes, sir.
Yes, sir.
Yeah. Thanks everyone for the warm words and this thing. Today, next 1.5 hours or 1 hour 45 minutes, what you plan to cover is the what are the concepts of arbitration agreement, appointment, selection of arbitration agreement, etc. Before we delve into, I thought to start the discussion with this thing. We like to keep the session as interactive as possible. I know it's a virtual session. Wherever you feel, you can unmute and ask the questions wherever this thing. 2 hours might be too small to touch. We are not in this session, we are not aiming to cover everything for this thing because in India cases etc keeps on happening. It's only just to give a framework how the case has evolved on each of the point. Law changes, cases come, cases again evolve. It might be a full circle, etc. Like unilateral appointment of arbitrator, judicial intervention, how the courts prior to 2015 amendment and post 2015 amendment. That is a few things we will be touching upon in the next 1 hour. Before starting, I just thought of touching on few things. Like, what do you think? What is the number of criminal cases or civil cases pending before various high courts, lower court, or in the Supreme Court? You have any idea? Anyone want to make any guesses on the same?
So it's somewhere around 4.6 crores as per the last report.
You are very close to it. So, if you look at the litigation in India, both on the civil side and criminal side, it's almost 5.3 is the amount of cases pending in the across various forum, which includes 4.5 crores of cases in the lower judiciary, high court 50 lakh almost, and approximately 1 lakh cases in the Supreme Court. What I just want to set the picture is that yes, in India, litigation, every matter is highly litigated. Every party like to litigate the matter all the way till Supreme Court. The reason being is that if you lost, you always has a hope that in the next level something will happen. Also, cost of litigation is not so much compared to the other jurisprudence. And in India, presidential value is not followed so strictly. Every judge like to be creative in the way to distinguish the earlier judgment or give something which is and adding to the knowledge for the next generation. So in the process of adding or writing the long judgments, etc., everyone has something to distinguish each case to come out. So presidential value, the strict discipline in the presidential value is also a reason why the delay and this thing. And everyone like in the DMRC matter, having a curative petition to get a relief is a hope for everyone on high stake arbitration matter to after review try curative. In the arbitration, like in India, arbitration has also seen ups and down. If you look at the like data, etc., there are gaps. Maharashtra, the Mumbai Commercial International Arbitration Center is a newer this thing. Number of cases filed is only very small, 38 cases. Delhi, the arbitration center under High Court, which has been quite popular, which has like the standards and institute this thing, they have been in the position of last year to reach 10,000 cases. But in 2023, civil matters filed in the Delhi jurisdiction is around 1,20,000. But arbitration matters are only 7,000. You remove family law, you remove other real estate, etc., which are outside. Still, a lot of litigation because at the stage of drafting the contract or at the time of this thing, since clauses are not there, you don't have option to go for arbitration. Then once the dispute comes, since the clause is not there, parties not agreeing for arbitration. Even though court suggest go for mediation, court for this thing, but still that becomes an empty formality. Also, initially there was so much hindrance against the this thing, but slowly industry accepted arbitration as a way forward. But what they felt or the period it is costly and time taking. There are various other reasons, even though limited review or limited power of challenge was there, but within the limited this thing, judiciary was curving out various exceptions. That has created ups and downs. After 2015, the new amendments, we are seeing again industry reposing the faith in the arbitration, but there are few steps taken by government, etc., to say that arbitration, etc., should not be first preference. So even industry is looking, if government itself, who is the largest litigator in the country, is thinking whether arbitration, like to 2024 official memorandum, they say that amount more than 10 crore as an exception only arbitration should be taken. Commercial courts should be used. So if you look at, we saw Delhi, which is a one state or one union territory where 7,000 cases. But if you look at the cases with a popular Singapore International Arbitration or London Arbitration or International Chamber of Commerce, they don't have so much caseload. Caseload in the Singapore, which is highest, is something around 600 cases average in a year. COVID year, they had a huge case of 1,000 number, but that was due to non-clubbing of few matters, etc. Between all the international arbitrations, Indian parties or both the parties or dispute is caused the Indian government, etc., are very minuscule for the London court as well as International Chamber of Commerce arbitration. Singapore, out of 600, 200 matters which involved Indian parties. Almost 30% of the matters in the Singapore international arbitration had India as the party. Multiple efforts has been taken to reduce the pendency, etc. But based on the data available today, approximately somewhere around 10,000 arbitration matters are pending before various high courts. In the thing, it does not include what's the matter pending in the arbiter after constitutional arbiter not passing the order, etc. And the fewer smaller high courts, etc. are not covered. Only the bigger high courts are covered. But what thing is they observed is that even in arbitration after fast tracking, doing everything, still it is taking 4 years for disposal of the matter in the high court itself after trying to fast track everything. If you look at the average for the OECD, etc., it's 1/3 of what is the time we are taking. Ours is approximately 1500 days. So other South Asian countries, OECD is at 600. Our endeavor is to reach at the thing. We can see some changes in the arbitration law, etc., to meet that objective. Before getting into the subject, why I gave all the statistics, to give a background that all the lawyers or whoever, all of us are studying law in the third year, etc., litigation as a lawyer, there are a lot of opportunity in the arbitration or any other matter in India. Our economy is growing, but we are also more formalizing our economy, contract, etc., which was not like it was our economy or business was more based on trust. From the trust, it is moving to contracts, which was always followed by MNCs. Advantages of having a formalized structure when the dispute happens, etc., Indian businessmen, MSMEs are realizing. We are also seeing multiple reforms, like IBC was a landmark reform in 2016. What we see is that there will be a wave 2 of reform on IBC to more strengthen, make it more faster, etc. Similar thing will happen in arbitration. Like way today, Singapore, 200 Indian matters are getting arbitrated in this thing. India want to promote Gift City as a center of arbitration. Gift City is a SEZ outside for the purpose of tax laws, but for the purpose of India, it's part of India. So the administrative jurisdiction for the purpose of Gift City comes under the Gujarat High Court. So they are thinking to have a dedicated bench for arbitration in Gujarat, etc., so that it is fast tracked. Any matter coming from the Gift City, there is faster response, etc. Like Singapore or Australia, etc., as a separate division benches in their courts. When the court is acting as a supervisor, because of court, there will be no delay attributed. So all these lawyers who are this thing, like 2 hours might be too small for you to grab many things, but you should always have an eye for detail. Whenever the client comes and tells the fact, every correspondence, every pre-bid, post-bid, clarification, letter, communication, engineer saying, every correspondence is a evidence. It is as material. So whether it is arbitration matter, litigation matter, or giving an opinion, all the situation or doing a DD for a M&A transaction, the detail is important. Research. Today we have got multiple tools or helping us to do this thing. When I look at AI as this thing, think about the time 30 years back when Manupatra, etc., or SEC online, etc., were not available. You are reliant only on the books. Case law, you read once, you have to memorize it and keep, so that tomorrow, like case law digest come, every read and keep, so that tomorrow you get a brief. You are able to correlate which case law where you read. You cannot go back and keep reading entire book. So at the time of reading, digesting, and keeping was very important. But what happened with the Manupatra, SEC online, etc., search function has enabled, saying that based on the facts, prompts, etc., you are able to search and pull out the case law. So memorizing the exact citation, etc., has become relevant. But end of the day, skill to do research to find a case directly applicable is important. Manipatra or SEC will aid you. Similar is the situation of AA. AA is a tool. It will going to help us with the research. It will give a jump start. But end of the day, the jump start is going to be available for all the lawyers. A person smartly using AA might have a little more better jump start. But end of the day, channelizing that to your evidence, your facts matters. The research is linking your facts with the legal precedents to build a case which can, through which you can pursue another person to believe what you are saying. So you are for plaintiff, you will try to say that my claim is right, these are the facts, this is the case law. Another person is going to bring same facts, bring additional case law to say what you are saying is wrong, what he is saying is right. It's end of the day, which who is articulating, who is giving more authority will have an influence on influencing a judge to take a call saying that which case is strong or bad. No case is bad or good. It's end of the day in the hands of the lawyer who argues, who provides the material to make the good case bad and bad case good. Being a lawyer, there's no substitute for hard work. Every day, a new case law or a new this thing unsettles whatever was settled till that point of time. So you might be master till 2024 with all the arbitration case laws. A judgment in 2025 can unsettle the entire position. Whatever your mastery will not be of any use when you are arguing in the court. Either judge will pull you or the opponent will pull you. Keeping this in mind, moving to the workshop, uh, I'll organize this for the names which Dwarpal, etc. for all the 6 sections, etc. as very nice. I like it was a good this thing. So this part of current, yesterday you had an introduction. Today, current session will be covering arbitration agreement and appointment and selection of arbitration tribunal. How to conduct, what can be the award, how to write a award, what evidence to be led, how can you challenge a arbitration award, enforcement of foreign awards in India, etc., mock court, etc., will be covered in the subsequent sessions. In this session, we'll be touching on essentials of the arbitration clause, appointment of arbiter, when can be judicial intervention be there, and few case laws to show evolution of a principle. 1 or 2 situation will be covered. History of arbitration in India. It started with Arbitration Act 1940. Then as the law evolved, we also had acts to recognize the foreign awards, etc. New York Convention, we become the party, etc. Multiple things were there. After a point of time, they felt that it's a time for us to have a consolidated law, which is in line with the unilateral law. So 1996 was the Arbitration Act in the new form, which is aligned with the international practices as coming. History is of not much relevance. The process and procedure provided in those acts are not similar to what is provided in the 1996 Act. Subsequently, delay, etc., formalizing institution, etc., has led to the amendments in 2015. Based on the learning of 25 years, reforms of Law Commission committee report, etc., led to the first set of amendment in 2015, subsequently 2019 and 21. What is unilateral model laws? Anyone want to give full form of unilateral, or what does unilateral mean?
Sir, it does stand for United Nations Commissions on International Trade Law. It is a body of United Nations which promotes the harmonization of trade across border.
Correct, Anish. So unilateral is nothing to do with arbitration, etc. It's for international trade. They, as part of United Nations, when they are United Nations was created for maintaining security after World War II, maintain the peace. Then over the period, countries realized that the cooperation can be used for UNESCO, for cultural health, various other activities. They felt that cooperation can be used and brought forward. Unilateral is one of the organs or the cooperation coming from the United Nations to enable the harmonization of domestic law. It's not a convention. They are not asking anyone to come and sign. They're saying that when you're doing the global trade, having a same law in every country will be help in ease of doing business. A company in Germany doing business in Germany come to India, they don't need to have a totally different arbitration law. They don't need to have a totally different Information Technology Act, recognition of digital documents, etc. So, based on the consultation of the stakeholders, they come out with multiple model or the templates. Based on a template, up to the domestic law to incorporate. The difference between unilateral versus the convention is that convention is directly binding on the country signing it. Then they can make a after having a signature, they can make a domestic law. Here, after it's up to the country to enact the domestic law. The adoption provided under Article 51 or 253 is not applicable for unilateral model law. It's up to the country to adopt what should be the model law, etc. In our case, we have adopted 3 laws or 2 laws and one in discussion: cross-border insolvency, Information Technology Act. We adopted Arbitration Act. We adopted from unilateral. Now, coming to unilateral model law, there are 2 things. One is unilateral model law and unilateral arbitration rule. Unilateral model law, as discussed, it's a template for us. If you run section by section comparison between section 2, section 16, section 9, this thing, unilateral model law is almost similar to our law. We have adopted based on that. Our object clause itself says the reason for adopting is to do this. Arbitration rule is the arbitration rules like Singapore International Arbitration Centration. It's arbitration rule for permanent court of arbitration. The permanent court of arbitration, if you are referring any matter for arbitration in the permanent court, it will be decided based on the rules provided. Interstate arbitration, investment arbitration, contract-based arbitration, etc. It's more state specific than the party specific. Most of the arbitration are arbitration, like a company X decides to make an investment, law are changed. Then in case the law is changed, then arbitration can be brought against the country before the permanent court of arbitration. Those kind of things are usually the case load is like end to end over the period in the existence of almost 50 years. They have arbitration matters done by them are around 60 to 70 matters. In India, the legal framework is 1996 Act, which is based on the model law of UNICIT. Act is divided into 4 parts. First part is on arbitration, second part is on enforcement of foreign award, part 3 on conciliation, part 4 on supplementary provisions. We are more concerned with part 1 and part 2 of the Arbitration Act. Before we proceed further, I thought all of us can have a drafted arbitration clause. You got a broad introduction yesterday. You got a broad idea what is arbitration, etc. So you can draft a clause for yourself. 1 or 2 people can read whatever the clause read. It's just for the purpose that when we are discussing case law, you can compare your clause. How if this clause was there for arbitration before the court, will the court accept or not? It'll take 2 minutes for you to draft the clauses, whichever the way you want. If anyone has completed, can read out. If you want some more minutes, it's okay. Who want to read the clause?
Sir, can you please guide them to draft an arbitration clause because many of students are just
Okay.
started from third year.
No problem.
Yes.
So we will have a like whatever you felt from the basic English, whatever you drafted, it's fine. We'll go ahead with the this thing. You can see. So like in an arbitration clause, there is a something called governing law. How many governing law can be there? So there can be a situation of in an arbitration clause having three governing law, like or three law. I will not say governing law. There can be a law for the contract. The arbitration agreement itself can be governed by a this thing. That is this lex arbitri will only help for evoking how to go for the arbitration. What should be the process for evoking the arbitration? Then substantive law or what you call as a governing law, that will be the law which will be governing the contract. Then wherever you decide as a seat, law of that seat will be the law which will be deciding the procedural, etc. Like if your seat is London, London Arbitration Tribunal will be subject to the courts of London for this thing. In India, we had an interesting period from 2002 to 2012, Bhatia to Balco, where Bhatia court said that even for an international seat, India domestic, if there's no specific exclusion or clause to say that part one is excluded, Singapore arbitration, CT Singapore, still no specific exclusion, still court will have this thing. Subsequently, Supreme Court overruled to make it clear that there's a distinction between seat and the governing law. Governing law can be India, but seat can be different. We'll deal in detail subsequently. So there can be Indian court appointing a arbitrator in Singapore, which will be the seat of the this thing, governed by a English law. All these options are available based on parties to the contract. Who decides what? That was the opening line. This thing. Main thing about the arbitration is parties can decide everything. But if parties can decide everything, what is the role of arbitrator and court? Parties can draw the field or the playing field, but arbitrator and court need to play within the field what parties have drawn. Parties cannot draw something which is beyond the law or beyond provided under the law. So parties can decide the form. Like two Indian parties are agreeing for a law of Singapore law for as the substantive law. Because Section 28 of the Arbitration Act said that when two Indian parties are dealing, the question of it's a domestic transaction, law has to be Indian law. You cannot. So you are given the freedom. That freedom is not like unlimited freedom. There are conditions attached to it. Similarly, arbitrators will decide the merits of the dispute, procedure, interim protection, etc. Court has a limited role or to support and correct judicial review or the this thing. Purpose has been that there should be balance between party autonomy and the intervention, which like whenever in questions or interpretation of the clauses come, court always say it's up to the parties to choose. But what they choose is violating the natural principles of natural justice, is violating Article 14, is it under coercion, is thing. These are the few things court will keep checking. Arbitration agreement forms the essential or the foundation of the entire process. So to have an agreement, even if you don't have an agreement, there's no starting point unless court directs you to go and do, or after having a dispute to come to agreement. Because what we see usually practically is that after having the dispute, no one is interested to have an agreement to dispute, etc. Unless it's a high stake matter, they like to see it's a very technical matter on the defect, damage, etc. So agreement, the clauses should be very clear. Scope of the dispute should be like what will be subject matter of the dispute should be clear. Whether you want a single arbitrator, multiple arbitrator, whether you will be going for an ad hoc or an institute, seat, governing law, language, etc. should be provided. The 8 bullet points need to be captured somewhere in the arbitration clause. If you look at the legal framework, Section 5 talks about court has a limited role to play, limited intervention, unless provided as per the Act. So Act provides limited intervention for the same. We'll see what are the situations where court provide. Section 7 provides, so what is arbitration agreement? It's an agreement between two parties to arbitrate any dispute. Section 10 and 11 say party autonomy. If in the Section 11 application, etc. comes in place when the party failed to appoint, then challenge, etc. Part 1, there's a concept, it is that part 1 is only applicable for domestic arbitration. Part 2 is for international. That's not correct. Part 1 is applicable for all the arbitration, domestic or international, happening in India. If the seat of the arbitration is in India, then even for international arbitration, part 1 is applicable. Part 2 is only for enforcement or recognition of the award passed or having a seat outside India. What are the usual disputes we see? The usual disputes are disputes coming from the contract. Two parties enter into a contract to perform a contract. Then after that, there's a deficiency. Goods were supposed to deliver on 10th of every month. 2 times he has not delivered on 10th. Because of that, my production cycle is affected. NHA is given a contract for construction of road. NHA says that every kilometer you construct 100 rupees will be paid, etc. You have to have 100 people mobilization, etc. Contractor brings everything, but NHA was not able to acquire the land. Contractors performed its part of the contract by getting ready to do the contract on the mobilization date, but NHA has not provided the land. Since NHA has not provided the land, it becomes there's a loss suffering. The contractor need to pay rental for the machine, salary for the employees deployed. So that cost need to be recovered. With a mechanism, and a contractor will say, I need to get 200 rupees per day for all this thing. NHA will say, no, it's 50. Then starts the arbitration. Liquidated damage because of that, this thing. So these are the few issues we see. Construction contract, insurance contract, share purchase agreement, employment contract. These are the few sectors where usually high end of litigation happen. ONGC chairman, you would have seen recently, has made a statement like arbitration, like lot of allegation is there that PSUs are driving arbitration. PSUs are making it difficult. What ONGC chairman in the public forum has mentioned is that arbitration is a good solution as long as it is completed within time. Why there is a disputes? He's saying that being PSUs, because of CBI, vigilance, etc., every stakeholder who is need to take a decision feels little scared. They are happy to pass the buck to court, a third party to take the decision. Lesser flexibility within the or autonomy within the organization to take decision to accommodate each other. That creates a problem. Then vendors, he says that it's not only on our side. There are, because of bidding, vendors got quotes which are so low. A project which is to be executed for 500 crore, someone quotes 300. Being a L1, I need to hand over the project to L1, quoted 300 crore. But next day he understands he cannot execute in 300 crore, he needs 400 crores. Then he keeps coming out with ideas to have a litigation, recover the cost. Then once the bid is given, tender is given, less flexibility and rigidity is there. If there's a change, etc., happens in the contract, automatically cases are filed saying that if the scope was different, I would have made a bid. So those kind of issues also creates the problems and the disputes. As discussed earlier, courts are to facilitate, not to interfere. 5 clearly provides that no judicial intervention except so provided. What are the situations provided? There are only 6 situations provided. 1, if parties fail, help in appointing an arbitrator. Ask for interim relief till the time tribunal is created. Once you get an award, go for enforcement. When you're doing the arbitration, take assistance for evidence, and challenge and appeal. These are the 6 situations. Setting aside is challenge and appeal. 37, section 37 is also. These are the situations provided in the court where court can, in the act where court can intervene. Otherwise, tribunal is competent to decide everything. That is the approach. 2015 amendment re-emphasize tribunal is the should be the sole authority to do the things. If you look divide in stage wise, pre-arbitral, appointment of arbitrator and interim relief, during arbitration, help in evidence, post-award, appeal, enforcement, setting aside. These are the 3 stages where judiciary or the court can intervene. I would like to spend some time to explain what judicial intervention is allowed, not allowed. Patel Engineering is a famous case of pre-2015, this thing. It's a 2005 Supreme Court, where appointment of arbitrator was the question, whether it's an administrative function or a judicial power. If there's an arbitration agreement in existence, can a court simply go ahead and appoint? Court, do they need to exercise the wisdom or exercise at the time of decision? Court held it's a judicial power. Existence of arbitration agreement means I need to check the validity. Validity means I need to check whether claim is live, qualification of the arbitrator, process, everything. So Patel Engineering, Supreme Court has set this thing to say that at the time of appointment, they can go into all the question to see whether the matter is arbitrable, whether the correct process has been followed, etc. 2015, when they made the amendment, 6A specifically excludes to say that, yes, I am aware 2009 there's a deletion, but 6A said, whatever be the judgments prior pre-2015, High Court, Supreme Court, whatever be the judgments, for the purpose, only thing need to see assessment of existence of agreement. Once this assessment of existence of agreement is there, matter is full stop. Still, parties based on the pre-2015 jurisprudence saying that existence of agreement needs multiple things to be checked, hence matter need to be seen. Matter went up first time in Duro matter, 2017 went all the way till Supreme Court. Supreme Court said, after 2015 amendment, my hands are tied. It's a limited intervention. Agreement there, everything you go before the tribunal. However, Oriental Insurance and United Insurance, this is against Hyundai, etc. matters of 2018. When the matter reached Supreme Court expanded the limited intervention. Supreme Court went ahead to say that whether the dispute is arbitrable or not, that is the power I should have. 2019, court again said it's a limited scope after amendment. But Vidya Dolia, 2019 and 21, they said existence of validity will include to check contractual ingredients. Like a party, just because clause is there, non-arbitrable matter, a party should not be allowed to spend the cost, etc. We are here to save the party. Someone who dragging maliciously a party for arbitration to help. They went ahead and this thing. NCC, DLF, etc., 21, 22, etc. They said that we should apply the mind. Why we are applying the mind? To streamline the process. We are not taking away the powers of the jurisdiction of the arbitration tribunal. We are jurisdiction tribunal has. We are just streamlining the process. They come out with a test called the needle eye test. To say that needle eye test means that only in the special cases we look into it. Others we don't look into it. But after all this discussions, etc., now in 2024, SBI General Insurance matter, accord and satisfaction, whether like why insurance matters are very important. Because what happens in insurance matter when there's a claim, you make a claim for insurance, they say that your claim is 100, you take 50, you give a letter in writing saying that it's a full and final settlement. So people, to get the 50 rupees, people give full and final settlement. After that, can they evoke agreement? So people are Oriental Insurance, United Insurance, etc. They argued, saying that once the satisfaction, like waiver is provided that I have received full and final settlement, they cannot agitate the matter. Agreement is no more in question. But SBI General Insurance said that whether the agreement is existence or not, whether accord in satisfaction, whatever then is under coercion, economic coercion, they were in the dominant position. Because of that, they've signed, etc. Still need to be worked. It's a limited power. We'll go back. So 2015 Act came, 17 they reiterated. Now 24, after going the full circle, they have come back to say that same principles should be. But thing is that the deviation from 17 to 24 is based on Patel engineering and the jurisprudence developed in the pre-2015 regime. But a new set of judges after 24 might get influenced again with the where can I intervene, how much I need to go, should I apply the mind, etc. So that's what the judgments are on both sides. Depending on what case, how the facts are presented will make the difference. And judge will be this. So I just want to say that like within 10 years, the full circle, the court has come over the multiple cases. Limited role, plethora of judgments are there saying the Supreme Court affirming our role is limited. But I just want to take one case to see after Supreme Court saying so much what happens in some of the situations. It was a prestigious project for DMRC, Delhi Metro airport line. It was a line to be constructed from airport to Asian Games, Commonwealth Games village, so the athletes who is deboarding after the airport, they can come directly to the hotel. Target date for this was 2010 Commonwealth Games. However, it missed this thing, etc. They were not able to complete. There were two parties. One was DMRC to do the civil structure, that is construction of the pillar and the other civil work, and other concessionaire to do the financing, design, procurement, and installation of all systems. Electrical system, automation system, train set, etc. are for the other. Second party cannot work without unless the civil structure is electrification, etc. Civil structure is constructed properly. Construction happened after multiple delays, missing the 2010 deadline. When matter came for the final approval for allowing the train to run, CMRS is the safety commissioner. It's an independent body which to certify whether the trains can run on a track. They inspected. They said that there's a problem in the construction of the viaduct and the bearing, the joining between the pillar and the platform on which the railway track is laid. It's this thing. There's to be speed restriction. As soon as this was pointed out, the design people operating, they raised a complaint to DMRC because of this thing, the problem is there. Then they had a joint inspection. The joint inspection, DMRC agreed. Yes, there are this thing, we will cure. After giving a 90 days notice, concessionaire terminated the agreement. Concessionaire said that we are giving you 90 days to cure the defect or take effective step for curing. So termination notice, there is a condition in the contract before terminating for termination for this thing. So in this light of this thing, where have you cured, taken effective, termination is correct or not, they evoke the arbitration clause and 3 engineers were appointed. This is a factual matrix. Matter had 6 orders. 4 places, one party won, 2 places, another party won. End of the day, ultimate place it was won by the party won 2 times. So DMRC won in the curative petition. Hence, they won. So I need to take to the 2012 dispute started because line was completed in 2011. So within the defect liability period, clause was evoked. Arbitration tribunal considering of engineers after inspecting and going through the data, CMRS report, etc., concluded that there is a mistake in the part of DMRC on the construction side. So DMRC is liable to pay 7,500 crores. Single bench appealed that DMRC is liable to pay. DMRC filed the appeal with the division bench. Division bench said that tribunal has not appreciated the evidence, etc. CMRS, you cannot rely upon the CMRS certificate, engineers, this thing, etc. Hence, set aside. So first was a challenge under section 34. Second was a appeal under 37. After dismissal of Section 37, since DMRC won, Consortia went to the Supreme Court as a review petition. SLP, sorry, as a SLP under 136. SLP Consortia was upheld, review was dismissed, division bench of Delhi High Court was reversed, review petition filed by the DMRC was rejected. However, curative petition was filed even after review petition. Supreme Court interfere in the review petition is a rare. Like Sabarimala, etc. in recent times, review also interferes can happen only if there's a factual inaccuracy. Here, one step ahead, matter was taken up in a curative petition where they went into the evidence. The court held that tribunal has not seen. Did they cure? Answer is no. But did they take effective steps to cure the defects? There is no finding by the engineers. So defects were followed, saying that engineers were not effective in administrating this thing. But one thing the court missing is that as part of party autonomy, people technical in the field was there. The dispute was on the technical nature, whether there was a default in the civil construction. Engineers and the CMRS come to a conclusion that there is a defect. That's the raised. But court said that the wording of the award created the problem. Because of that, court set aside and this thing. Because whether judgment is right or wrong is different. But once the judgment is passed by the Supreme Court, since it is final, it is binding. You don't have any option. The curative, dismiss. However the good the case, however the bad the case, the final verdict in a curative is final on the parties. There is no other hope to do anything. So court have talk about patent illegality and miscarriage of justice. When you are seeing in the subsequent classes on 34 challenge, you will be seeing. Why I took it out is that limited judicial review. But in the judicial review also, a court can go into so much in depth to give reliefs to the parties. So two judgments I want all of you to read from this. Rest of the cases you can ignore. One of the judgment is Delhi Airport Metro Express, this matter 2024. It will give you a full perspective of how arbitration proceeding, how evidence, how 34, 37, review, entire appellate proceeding arbitral matter is provided, where you can go in merit, etc. So that gives a good perspective. This is a one case law from this entire session. I request all of you to take back to read. There's one more case law. I will come when I come to it. I will say appointment of unilateral arbitrators. Interim measures, etc. Court can provide. Section itself provides, it's a direct, and arbitrary tribunal can also provide the interim measures. Emergency arbitration, etc. comes from these provisions. As I said, we spoke about judicial intervention. Now comes the arbitration agreement, playing field for the gatekeeper. This sets the limits of everyone. It's very simple. It says that agreement need to be in writing. Parties can choose, submit all of you dispute. So in the agreement itself, the agreement you drafted, you can say all dispute arising in the contract I will give. I can write up saying that only the dispute arising to the change in law, only the dispute arising in the change in scope, only the dispute arising to escalation I will give to arbitration. So in the same agreement, part disputes can be arbitration, part dispute. But if wordings are ambiguous, it creates confusion. Arbitration clause in the main contract is a standalone clause. It does not need any separate consideration. Even if agreement is terminated, it will survive. Even if the agreement is void, this clause can continue. By conduct, etc., there are judgment to say that even though not writing, by conduct, etc., party agree. Because even though it's not in writing, by conduct, because law allows parties not having agreement also to come for arbitration after the dispute arises. So by conduct, exchange of letters, etc., if intention is there, arbitration agreement can be created. This is one clause. Dispute may be submitted to arbitration or any other method. Can it survive in the court? Answer is no. The reason being is that there is confusion. Dispute may be submitted to arbitration. May is creating the problem. Words like may should not be used. It should be clear. Shall. Then any other method. So when they say any other method, person is saying that I am happy with litigation, I am happy with arbitration. So those intent to arbitrate should come from the clause itself. Intention, arbitrate plus litigation is there. Court can take both the views. Court can say that I will say the remaining part of the section is bad. I will say dispute may be arbitrated. Instead of may, dispute shall be submitted to arbitration or any other method. Instead of may, shall was there. Court could take a different view to say that intention of parties for arbitration, court said shall, any other method can be deleted. So those kind of adjustment, etc., court is allowed to do. Why it is important to get the clauses right? If the clauses are not right, it will cost, it is a unnecessary litigation cost, it will cost delay. At the time of appointment of arbitrator, jurisdictional challenges, governing law, because you do everything. If clauses are bad, it can be challenged even at the time of enforcement. You got an award. When you go for enforcement, court can set aside, saying that this issue could not have been arbitrated. It's going beyond this thing. So after spending 5 years getting the award, doing everything, appeal, challenge, etc., when you go for enforcement, again, ground can be taken if there is a patent illegality. Few clauses will you give you a understanding. Just if during, these are the clauses from the judgments where the clauses was disputed. If during the continuance of the partnership at any time afterwards, any dispute touching the partnership arises between the partner, same shall be mutually decided by the partners or shall be referred to arbitration if the parties so determine. So word is or. Since there or etc., consensus is there, addendum is there, both the parties agreed or not. Court said that this clause is invalid. Look, after having arbitration, you spending the time for appointment arbitration, etc., court is saying no. Arbitration clause saying one-way arbitration, saying that only distributor can appoint, manufacturer cannot arbitrate. Like, I will go for litigation, you go for arbitration. If I have a case against you, I will go for litigation. But you have a case against me, you have to go for arbitration. Courts have had such clauses are invalid. Clauses in the invoice, etc. All dispute regarding this invoice will be settled by Delhi Hindustan Mercantile Association. Why this clause is bad? It's bad because you cannot have, invoice is not an agreement. Invoice is a document evidencing a transaction. It's first thing is that arbitration agreement is to be a contract. Both the sides should agree. So this kind of clauses, which is on the side, etc., it's difficult. Invoice is a unilateral act. There are multiple plethora of judgment. There should be contract between party, etc. This thing. There was a word. Instead of using arbitration, the word used is settlement. Any dispute between the parties arising out of pertaining to any matter, etc., referred to a CMD of the principal for settlement, and whose decision shall be final and arbitrary. This thing. So this, because the word settlement, court said settlement is different from arbitration. It cannot be. CMD for if the word was arbitration, this clause would have flew before 2015. Why I'm saying before 2015? Because after 2015, employee of the company cannot be an arbitrator unless expressly permission is given by the other side. What happens in the long-term contracts which are running for 3 years, 4 years is that there's a contract original, then there's a supplementary contract. There's an original loan agreement, then there's a supplementary loan agreement. Because formats get changed, etc., over the period. Original agreement, the intention was litigate. Subsequently, the party decided that now onwards I will go with arbitrate. So within the multiple documents, one way arbitration, one place litigation, etc., then creates the confusion. So whenever there's a subsequent or subsequent documents are there, always try to link the document to see jurisdiction is correct, is same as the earlier. Otherwise, at the time of going for invoking the arbitration, jurisdiction is in this court, that court, etc., becomes the points of litigation. There was a, like, it's a very interesting clauses. In the arbitration clause, there was a clause to say that only claim will be there, there can be no counterclaim. Court said that those kind of restriction cannot be provided because counterclaim is something provided in the act itself. You cannot restrict what is provided in the act having a clauses like this. Another, there was a clause which talked about that if you have to evoke arbitration, you have to make a 10% pre-deposit. Court said that it's a private party. If unless the Arbitration Act provides for that, you cannot say this is to prevent arbitration, etc. The clause said to avoid frivolous claim, we are asking. Court said that whether the claim is frivolous or not, tribunal will decide. Putting a 10% burden, you are asking a party to out of pocket before he starts the litigation, asking for his due claim amount. Clause in the tender document, unless tender document is incorporated by a subsequent agreement, it's not binding. At the time of tender, there's an arbitration clause. That does not mean that you can evoke arbitration. The reason being is that at the time of tender, there's no acceptance by both the parties. It's a one-way document. Once you accept the tender, you become the L1, you become, in that situation, only arbitration clause from the tender document will work. One party is giving multiple contracts. Can we go under this thing? Prima facie principle is that one contract, it's one arbitration. You 10 contract, 10 arbitration, it will be separately arbitration. But there are exceptions where multiple matter, one tribunal has been accepted, where there are situations where court has rejected also. Like Duro Felgora, which we discussed, that limited judicial intervention. There 5 agreements with the same parties, they wanted to have a one common arbitrator. Court said that 5 agreements, 5 clauses, separate things should apply. So doctrine of severability is applicable. Clause is standalone clause. Court can modify. Like the first case, Delhi High Court, they said 2 arbitrators. 2 arbitrators are not permitted. Even arbitrators are not allowed. Court could have said clause is void, ab initio. No arbitration, go for litigation. But court said that intention is there to arbitrate. 2 arbitration is a mistake. I'll correct it by substituting even to solve. There was a case of appointing an arbitrator. Appointing an arbitrator was to be appointed by the company itself. So they said that it's a unilateral appointment is incorrect. You are appointing an employee. Court said that intention to arbitrate is that process is incorrect. So they said, entire agreement I will not invalidate. I will appoint another arbitrator. High Court judge was appointed to continue. So curing the defects in the arbitration clause, some situation court can cure, some situation they can say it's invalid. It depends on the situation and the facts. That's the only thing I just want to highlight. So what I showed was that clauses court can say invalid, court can cure. So it depends on the facts and circumstances and what is the situation. So second aspect, what we like to see that subject matter, number of arbitrators, safeguard against the bias. So these are the second set of topics we'll be covering in the next 30 minutes. If you ask the thumb rule is that every matter is arbitrable, which is right in personam, one-on-one, contractual remedies. When it is a right in rem against the world, then that is not arbitrable because every party is not party to the contract to give. Example like IPR, you cannot bring a case to say that someone is infringing because it's a right you are against the world at large. So that you bring in the court, so any other third party, affected parties can come. So right in persona can be arbitrated, right in rem is not arbitrable. But matrimonial dispute, it's criminal offenses, they are right in personam to an extent, etc. Criminal offenses, offenses against the state, etc. Matrimonial. So these are the example where Act itself provides this cannot be arbitrated. So thumb rule is whatever is right in personam can be arbitrated, but there can be situation where Act prohibits arbitration over those kind of disputes. The non-arbitral subject matter, Vidya Drolia is the landmark judgment on this point. What can be right in term, what can be this thing. Here, the court held like immovable property, lease, etc. Sale of immovable property cannot be arbitrated. Right, lease, etc. arising from the land is a contractual right. Those to the extent what is the contractual right that can be arbitrated. Institutional and ad hoc arbitration, yesterday I understand it was discussed. We are not getting into this thing. Institution is more streamlined, formal. Ad hoc is that more freedom and flexibility. So ad hoc is more, some of situations cost effective, but there are challenges of ad hoc is that there's no skeletal mechanism. There is no secretariat to support. Like in case of institutional arbitration, clause can be very simple. Appointment, etc. There's a defined process. There's a defined timelines. In case of ad hoc, every timeline between the parties, he need to discuss and decide. In institutional arbitration, as soon as you know by when you need to make a claim, when you need to complete the pleading, everything is this thing. Exception, you ask the institution to get. So there are advantages of institution, advantages of ad hoc. There's no straitjacket formula, what should be right or wrong. Cost, etc. can be the factors. Similarly, single arbitrator, three arbitrator, end of the day, three people looking into something, it's always better, but decides whether the amount is huge enough, etc. for taking the decision. We discussed on the judicial intervention. Similarly, I want to touch upon another issue of unilateral appointment, this thing, where how the courts have intervened and what is the final decision. 2015 Act, prior to that, there was not so much on the arbitrator. Generally, arbitrator should be impartial and neutral, but not codified. 246 Law Commission report based on International Bar Association came out with a traffic light system, which is called yellow, orange, red. Red are if there is a arbitrator having bias, etc., which is falling in the red list, then he should not be appointed at all. But it is orange or in case of orange, it's up to the parties to waive the right and take it up. When India adopted the Law Commission report in this thing, they said that Schedule 5 gives what are the situation of bias or impartiality or of the arbitrator. They are given this thing. Schedule 7 also give de facto D0 ineligible. There's an overlap between the Schedule 5 and Schedule 7. But they say that you make a disclosure. Whenever you appoint an arbitrator, you make a disclosure as far as fair and possible, covering everything. Protection is that bias can be avoided. Grounds, justifiable grounds, doubt can be that have you worked as a previous, have you advised the company, you worked as the employee, you worked as the this thing, etc. Any relationship with the claimant or the respondent. Similar, arbitrary relation with the parties, 7th schedule again talks about direct and indirect this thing, etc. There's an overlap between the 5th and 7th schedule. Section 12.5 provides that even after 7th schedule, in writing, people can agree to go ahead and go ahead. If people don't agree, then waiver cannot be affected, problems can be created. The award passed by arbitrator disqualified under 7th schedule is not considered in existence at all. You get an arbitrator who has made a disclosure, but the other party has not given a waiver under 12.5, then entire efforts goes down the drain. So what are the stages in which you can challenge the arbitration? If it's a Schedule 7, because that is a red list, that can be challenged at the time of appointment, during the proceeding, or at the time of appeal or enforcement. At any time you can challenge Schedule 7. But it is a Schedule 5, justifiable bias, which is in the orange list. That can be challenged only by way of appeal. It cannot be challenged at the stage 1 or stage 2, only at the time of this thing. So bias, etc., falling in the schedule makes a difference at what point of time you will be able to challenge. To give party autonomy, they have given the option saying that even after having a Schedule 7 exclusion, you parties in writing can waive after the dispute has arisen. You cannot take the waiver in the agreement clause itself. In the arbitration clause itself, you cannot take for the waiver. Waiver has to be after the dispute. Parties say, I am fine with this arbitrator. I am fine your employee working as the arbitrator. If he has not given consent, those arbitration can be set aside. So in light of this thing, I would like to discuss the unilateral appointment, etc. So we discussed like intervention is very limited when party fails to appoint, etc. Number of arbitrator, etc. Full freedom is given. So few clauses from the PSU arbitration. Dispute shall be referred for adjudication through arbitration by sole arbitrator appointed by the CMD. So one party is saying that arbitrator I will appoint. You are both of us are party to agreement. You agreed. Is it fine? Dispute shall be referred to a sole arbitrator nominated by CMD. Dispute shall be referred to CMD. So one place it is appointed by CMD or nominated. Another place it is CMD himself, who is a current employee, is acting as the arbitrator. This kind of clauses, will it work or not? So appointment of arbitrator pre and prior, there is a stark difference. Day and night difference are there. Like employee as arbitrator prior to 2015, plethora of judgment, Supreme Court has said it's fine. When they're conducting the matter, the employee is technically aware. When he conducting the matter, as long as he is impartial and neutral, there's no problem. In the conduct, if he is doing something which is biased, then you can challenge. As long as in the conduct of the proceeding, he is not biased, employee being appointed as arbitrator is fine. So PSU contract, which is a one-way contract or general conditional contract, etc., no tender, etc., NHA, ONGC, Indian Railways, etc., this kind of clauses were prevalent. Law Commission said that party autonomy is fine. The parties are agreed, whether under coercion, with standard contract, etc., it's fine. But integrity of the process should be there. An employee of the company working will always has a bias for the company. So party to the dispute employed by this thing cannot be the arbitrator. This was the recommendation. But they said we want to promote party autonomy, real and genuine party autonomy. Hence, 12.5 is there. I am giving the right to waive in writing. If the party waives it, fine. Party does not waive, this clause will not have any meaning. Post 2015, I would like to take through the series of judgments, but we'll come to the main judgment at the end. 2015, 7 TR of Bharat Broadband. They said that unilateral appointment where MD of the party is appointed as arbiter, they said that it's incorrect. After 2015, employee being appointed or employee nominating a person, both the scenarios are incorrect. So first set of judgments saying that unilateral appointment and employee or the party nominating is incorrect. Same thing was again reiterated in 2020 in Perkins. They said that unilateral appointment party interested is a bad in law. So questions arose was that CMD nominating a person and employee work. A CMD is nominating a judge. Can it work? Like he has nominated an independent this thing. Bar is nominating the bar or bar is acting as an arbitrator. So few of the judgments came to say that as long as you are not acting as arbitrator, you are only nominating, unilateral nomination is fine. After Perkins, Aditya Birla Finance, McLeod, etc., they said that ineligibility only relation directly fell in the 7th schedule, if not only because they are unilaterally. So unilateral appointment, initial set of judgments wherein against the assessee, then they said the unilateral appointment is fine. There were the clauses because waiver need to be there. The clause itself had this thing that contract no person other than person appointed by the appointing authority shall aforesaid act as arbitrator. If any reason that is not possible, matter shall not be referred to arbitration at all. So take it or leave it. I appoint an arbitrator, you accept it. You don't accept it, no arbitration. Court said that the second part of the clause saying that matter is not referred for arbitration itself is incorrect. That is said that need to be struck down. So PSUs, learning from that, you need to get a waiver. Clause itself, they added this thing. The clause itself will not work for the fact that 12.5 says after the dispute arises, you need to have in writing. Having this clause in the agreement itself is incorrect. So unilateral appointment become a challenge. So question arises that can I have a panel? Having an appointment from the panel is a correct or not? So having 30 employees is a narrow panel, broad panel. So question has been that court have been saying that panel appointment is fine, but panel appointment should be a broad panel covering the situations. But if you look at the high court level, there are all types of judgment. Having only 5 employees, court said it's not a broad panel. Former employees, 5 names of the retired employees of the Indian Railway, they said that not good enough. 4 names is not a broad panel. But Core 1 2019 judgment, report in 20, they said exclusive for retired employees, it's fine. The Supreme Court is saying that having a unilateral, it's not a unilateral appointment because you are giving a panel. It's up to the party to choose. Having 4 people in the board is good enough. Railway, your employees being in the past retired employees is not a problem. The reason being that they know the technicalities of this thing. Court upheld. This was subject matter of reference, etc. So Perkison said unilateral appointment is bad. Court held that power to appoint a panel letter from the arbitrator is fine. Court said railway retired employee is fine. So ineligibility criteria was there. So because of this thing, in Tanisha construction, matter was referred to a larger bench. So the larger bench again discussed all the issues. The larger bench said that this is the second judgment I want you people to read. First judgment which I spoke was on the judicial intervention, how the judicial intervention happened in the DMRC matter. Second judgment is Core 2 of 2024. Core 2, they discuss all the cases which has happened from 2015 till 22. Appointment by panel, appointment by unilateral, etc. As well as unilateral model. They said that unilateral appointment, unilateral panel is not an equal treatment. Both the parties should have a counterbalance. Like there's like I should nominate, you should nominate, both should agree. It should not be that you nominate, I have to take. That is not permissible. So it's a 5-bench constitutional bench. Even though it's a constitutional bench, there are 2 judges who given a dissenting. Even in this, the equal treatment of party, you cannot mandate the other party to choose from the panel. But 12-5 exception is still available. It's up to the parties to waive the right. So unilateral appointment, appointment from panel, appointment of employees. You see plethora of judgments. Entire this thing has come full cycle by the time when the core matter came, Core 2 came in 2024. So what is it? It's an evolving judiciary. Like after the amendment in the act saying that bias, etc. are the reasons, all these things has happened. The earlier judgment we discussed about the judicial intervention. After having a specific amendment 15, again all the discussion has happened. Nominating from the sole panel, answer is no. When there's an appointment procedure, like problem in case of arbitrator is given to the court always tend to appoint a judicial person, senior advocate, retired judge, etc. Matters which are construction, delay, technicalities, etc. Like DMRC matter, it was a quality of construction where the pillar and the bearing was correctly, load bearing capacity of the bearing is correct or not. So those kind of things, it's always better to provide the qualification so that you get a person expert from the field appointed. If it is vague, court will appoint any person. If the procedure is provided or the qualifications are provided, court will follow. Institutional, etc., automatically they have the checks and balances. Retired employees, judgments are there in favor, but after the larger bench, all these judgments will not be of any use. Grounds for challenge we have seen at the time of appeal of the appeal, enforcement, during the proceeding, or appointment of arbitrator. Unilateral appointment. So this is in the Bharat broadband is the case. The party who appointed the arbitrator unilaterally, He went ahead and said that the arbitrator I appointed is incorrect. Court said it's a question of law. Since it's a question of law, it's fine. You can go back on your words. You appointed this fellow, you're saying that it's unilateral appointment, go back. Court gave the relief, saying that it's a void ab initio. Even though the party who passed the award was appointed by the person who asked to set aside the award. Objection can be made at any stage. Emergency arbitration, it has become quite famous because of the Amazon. Amazon, in the case of Future Retail, when they evoked the emergency arbitration to get this relief, but emergency arbitration, etc., are not provided. Institutional arbitration rules provides for that. Now, arbitration clause does not provide for emergency arbitration, etc. It becomes a question, court, did the parties intend? Then you need to argue when there is a arbitration, award can be given, interim powers can be there. Emergency arbitration, nothing but an interim measure. It becomes a dispute. Once it becomes a dispute, you can argue all the way till Supreme Court. Even though the Supreme Court has said emergency arbitration as an interim measure can be done. But when you file an appeal, court need to spend time to take a decision. You are substituting an arbitrator for whatever is like death, etc. You have to follow the same process. What is provided in the agreement. You cannot override this. So what we saw till now is the appointment of arbitrator, process you provide, etc. has the impact on the time or the speed at which decisions can be taken. Timeline to apply, Limitation Act applies for arbitration. Within 3 years, you need to cost arising, you have to take appointment of arbitration. Supreme Court in a passing remark, when Justice Chandrachud was Chief Justice, he had requested government to relook it. He's saying that having 3 years is a long period for commercial disputes. It is creating a delay, etc. But government has not acted upon this recommendation till now. Reference, etc. Like standard agreement having a reference to this thing, it's always better to have arbitration clause made part of the agreement, specifically incorporated. Well, this you need to lead evidence to say arbitration was our intention, these two documents to be read together, etc. So 2015 amendment has provided the time limit, fees, etc. Time limit, they have said 1 year. Parties can extend by another 6 months. 19 amendment, again they extended to say that till the time pleadings are completed, because pleadings are not in the hands of the arbitrator. From the pleading time should take, etc. Fee, etc. Whether the fourth schedule to be provided, followed, etc. Some of the cases we are seeing high courts are modifying others. Otherwise, fourth schedule should apply for the fees and the ceiling. Multiple arbitrators. Question was that fee is capped for the entire tribunal or the single arbitrator. It's for the single arbitrator. So few of the clauses which we thought we should avoid. Dispute shall settle by arbitration in court. So word arbitration is there, court is there. We have seen the case law, court setting aside. Arbitration will take place as per international law. But it is not providing which is the governing law, what rules, etc. Then it becomes you have to lead the evidence, what is the subject matter, which has the more material connection to the matter, which law should prevail, etc. There will be arbitrators chosen by the parties. This kind of clauses will not say whether it's a sole arbitrator, multiple arbitrator, three arbitrator, etc. Arbitration shall be under the rules of International Court of Arbitration of London. There's no institute called International Court of Arbitration of London. So this itself becomes, since there's no institute, you're referring to the institute is incorrect. You have to go to the court. Court need to take the decision. Rules of international arbitration shall apply. So always be specific or incorporate the clause of SICA. Incorporate the clause of London International Arbitration Center. Because all of them are standard clauses which takes care of almost all this thing. All this, any defect in the drafting will delay the appointment of arbitrators. Delay in the arbitrators means delay in getting the claim. To the time we are out of pocket for the money, whoever is making the claim. Multiple jurisdictional challenges, court intervention, Then finally at the enforcement stage also delays can be caused because of the wordings of the arbitration clause. Few things I just want to touch. 2015, government made the amendments. 2016, our PMO had made announcement that we want to build a global ecosystem, something similar to Singapore, for international arbitration in India. But over 8 years from 16, 24, what we are seeing is the government really saying that arbitration should be done by the government for matters less than 10 crore. Institutional arbitration is fine. So this has sent a very wrong impression to the entire companies, saying that should we go ahead with arbitration? MNC clients, etc., or the international clients who are bidding for the Indian projects, they feel the government is not saying arbitration, then why should we take, should we not take? But arbitration is more a predictable outcome compared to the court, which may be much more delay. With the amendments in the timeline, etc., we see this thing. And government is thinking more reforms and also arbitration seat based from gift city. Those kind of reforms might help in the changing the scenario as a whole. Just want to take a situation. This is the case pulled up by the Supreme Court, the Allahabad High Court, and the Small Causes Court in Lucknow. The matter was 1992 matter under 1940 Arbitration Act, not even under 96 Act. Still pending. That's what 1940 Arbitration Act. 92 award was given in favor of Chopra Fabricators. He was the proprietor. He got the award in 1992 saying that public sector undertaking need to make the payment. At that time, there's a concept called finalization award. For that, he need to approach Small Causes Court. It took 10 years for him to get a finalization from the Small Causes Court. After finalization, party did not file appeal. They agreed that award given is fine. He agreed but not paid. Since arbitration award decree amount was not paid, he had no option to go for enforcement. So 2003 itself, he filed an enforcement application. From 2003, 20 years matter is pending, but 150 times matter is heard or listed, no real hearing has happened, enforcement action could not take. He went to the Allahabad High Court in 2021. I am almost 90 years old. Considering my old age, please direct them to pay or hear the matter enforcement fast and pass the order. Supreme Court, High Court said, no, we will not interfere. This is interfering in the judicial, this thing, delay, etc. is part of it. Matter was approached to Supreme Court. Supreme Court said that this kind of delay cannot happen. Supreme Court gave a passing, etc., asked to do this thing. So what I want to highlight, like in India, unless parties push hard to get the date, move the matters, etc., every stage, every appeal, every enforcement, multiple reasons for delay can creep in. So parties need to be vigilant. Ask lawyers for the parties, ask the instruction of the lawyers. We need to find. These were the two sample arbitration clause which you can use. Like if it is an arbitration clause, institutional arbitration clause, rules of arbitration of Indian Council of Arbitration, they will take care. Clause can be very simple. But if it is ad hoc arbitration, we need to talk about arbitration shall be conducted in accordance with the Arbitration Act, rules made thereunder. Party failed to appoint arbitrator within 30 days. I'll go to the court. Institution automatically it provides. You don't need to say that 30 days, this thing. According to the provision, the seat or the venue of the arbitration shall be New Delhi. Proceedings shall be taken in English. Arbitration award shall be final and binding on the parties. You can compare with the clauses you drafted in the initially, whatever missing, etc. You can improve based on this thing. Like if you want to look at a checklist, clear intent to arbitrate, scope of dispute, number of arbitrator, method of appointment, seat, language, governing law, institutional versus ad hoc, applicable rules, finality, and contingent. These are the 8 to 9 points which we should keep in mind always when we are drafting a arbitration clause or arbitration agreement. standalone or part of the main agreement. Takeaways from the session, what I thought to cover: subject matter, ad hoc versus institution, soul, etc. We covered. These are the things you should treat it. Evoking time, limitation, etc. My only takeaway to you, all of you, is that there are too many things. There are every day High Court and Supreme Court arbitration judgment keep coming. You need to be updated. Core 2, which is talking about unilateral appointment, etc., gives you a good flavor on appointment of arbitrator, and DMRC matter gives you good flavor on the end-to-end arbitration proceeding, how it happens in India. So these are the factors while choosing the arbitrator. Like, this is at the time arbitrator, the parties can decide knowledge, timeline, etc., past contact, etc., can be used. This is the broadly the points what I thought of covering in 1.5 hours. We can discuss any questions, etc. We have got another 15 minutes.
Sir, I have a suggestion or a statement actually, maybe a doubt. So, as you discussed the Chopra fabricators case, so the uh, enforcement was put up in the year 2003, and it was not even given in 2020 as well. So, don't you think that arbitration, which was supposed to be agile and a meticulous form of help to the general companies or any entity, was should be supposed to be quick? That's why people choose arbitration, right?
No, objective is that you are not bound by evidence, you are fast, etc. But there are, as we discussed, the pendency of litigation in India is so huge. Government is looking into it. Government understands the problem, but it will take time. But if you look at, Supreme Court has given a direction that application for appointment need to be finalized within 6 months of filing. So there were situations, application to appoint the arbitrator used to take 4 years. So there was a Telangana High Court matter. When the matter went to Supreme Court, Supreme Court said all the High Court yearly basis report need to be submitted of any arbitration application. Appointment is taking more than 6 months. We cannot blame the judges. Every day, more than 60 matters are listed. The time limit available for them to do the matters are very few. Like, you can hear 5 to 6 matters a day. So the amendment proposed to have a separate institute, moving away from the High Court and Supreme Court appointment, etc., will be better. So it will take a little time to formalize the structure, etc. Yes, today there's a problem. Are you trying to rectify it? We are trying to rectify it. One good thing about India is that we have an impartial judiciary. A judiciary, we can vouch for that. Based on the principles, they will take a decision. When they take a decision based on principles, the principles may be incorrect. Like, it's another a judge's call. Judge is taking a call based on what is presented, based on the advocate who presented. A petitioner advocate was a respondent. A good case can be made, a bad case may be made based on what you argue and what you present. So judges cannot be blamed. They take decision based on what is this thing. Presidential value, as I pointed out, is something which we should work, but we don't have a discipline of having that. So let's see. It will evolve all the time. Like High Court, etc., time period for arbitration matter has come down with the commercial court coming in picture. NCLT, now they are looking into reducing this thing. So it's a work in progress. Let's wait.
Thank you, sir.
Okay, any more question from the
Sir,
student?
I have a question. Am I audible?
Yes, yes.
Sir, if an arbitration clause is silent on key aspects like the number of arbitrators or the governing law, how much courts can step in to fill these gaps?
No, so assume first we take the question that clause does not provide for anything. Parties don't agree. I say 3, you say 1. Matter goes to the High Court for appointment. High Court can look into the circumstances, and High Court can decide you go for solve, you go for 3. High Court can decide, because that's not it's just more an administrative function. Governing law, High Court will not interfere. Since you are not provided the governing law, let the arbitrator tribunal decide what should be the governing law based on the facts and evidence of the matter. Whether if the domestic transaction, purchase and sale between Indian party, they will decide based on the Indian law. There's a transaction between India and Germany or India and UK. English law should apply, common law should apply, civil law should apply. One party will say Indian law should apply, other party will say common law or civil law or English law should apply. Then arbitrator need to take in considering the fact that what is the core subject, which was the party supposed to do the obligation. One party is merely making the payment, other party is doing the manufacture, are the additional obligations. Court might come to a conclusion that Indian law should be taken. So then it becomes evidence and fact based to decide what should be the governing law.
Okay, sir. Thank you, sir.
Any more questions from the students?
Yes,
Sir,
good
if
evening,
it
sir.
Yes,
Good.
yes, you can
Yeah.
ask.
Good evening, sir. First, this is my first session, and we have been not done with area. So, if my questions are a little silly, apologies for that. My queries are two. First one is that you touched upon a slide where enforcement, which took about more than 20 years, and the oldest was about 40 years. Uh, can judgment be coming from the arbitration mentioning the timeline for the enforcement also when it goes to the litigation, so that this kind of a long period can actually not been happening? And the second question, the recent incident of a Ranjana movie which got re-released in OTT, where the climax was actually being converted using AI. Now, the original producers, sorry, the directors and the people were actually looking to file a case. What if a case where AI is getting involved and there is a arbitration coming in? How then the whole arbitration scope actually comes in?
Okay, thanks, Simul. So first we'll take the question on the what was the first question? Time. Yeah, arbitrator award cannot dictate what court should do. Enforcement is outside the purview of the arbitrator. Arbitral award will decide amount due is 100 rupees. This is the interest. You have to pay pre-decree, post-decree, all that thing. And parties can pay full stop. If party does not pay that amount, then you need to go for the enforcement. That has to be through the civil court. Because
The timeline.
No, they cannot put the timeline because High Court can give a direction to a subordinate court. The Supreme Court can give a direction to the supervisory High Court, not an arbitrary tribunal to the court. Any timeline can come on that matter is that if nothing is happening, go to High Court and ask for expeditious hearing. The matter, they went to Allahabad High Court. High Court said that we will not interfere. We understand that delays are fine. It takes time. Then Supreme Court interfered. Arbitral tribunal, a quasi-judicial authority cannot direct a court on timeline or give any recommendation on timeline to this thing. They can only decide the dispute and the amount due. Now coming to your question on AA, etc. So first, arbitration is dispute between the parties. OTT release of climax being changed is a question of who owns the copyright. Is the copyright with the director? Is the copyright with the producer? Usually, or 99% matters, all rights of the film are with the producer. Like you ask a painter to draw for you, you buy a painting. Once you ask the painter to work for you, they are just actors. Only moral rights are available with them. They can make hue and cry, but that hue and cry does not have any legal. Like ending was, say, you do something in the ending which will harm or bring bad reputation to the director's work, then he can challenge. He get a legal right to do. So it's a dispute. So in the original agreement between the director, when the director was appointed by the producer, there was a clause saying that climax cannot be changed without my permission. I can change climax as this thing. Then there was arbitration clause. A is a tool used to change, bring the effect. Dispute is between the party. What is the conduct and what do you agreed will happen. You are not entering the contract with A. You are entering the contract with the parties. Like you have agreement with ChatGPT for use their services. Because you rely upon some information on ChatGPT, you are going to draft a petition. ChatGPT will create a case law and give you. You go to court, you argue. Court said that there is no case exist. Then you cannot come and sue ChatGPT. There's a breach of this thing. But ChatGPT has given enough disclaimers saying that you cannot rely upon me. I am aiding you. So if ChatGPT says that my algorithms are good enough, my prompts are good enough, I will not hallucinate. Whatever I give is a correct. You rely upon it, you incur a damage. Then you can bring it back and sue against, not against ChatGPT, against the company owning ChatGPT. OpenAI and you have a contract. Breach of that contract, it's a tool provided like cloud services given by Amazon. You lose the data. You will not file a case against the cloud. You file against the Amazon. Exact is the case with the AI. AI is just a tool. The person who providing the service using the AI, your contract is with them. If there's a breach based on the clause, it will be implemented. Shankar, clear?
Thank you, sir.
Yeah.
Sir, I had a question. If a dispute is pending before a court, can one party compel arbitration?
One party cannot compel, even court cannot compel. Court can suggest up to the parties to agree. Arbitration, party autonomy, one party, because I had an option to go for arbitration. I did not put arbitration. I want to litigate. Then court cannot force, please do arbitration. Court can suggest you do mediation, you do out of court settlement, you do arbitration. Both the parties not agreeing, it cannot be compelled or pushed on the parties.
Okay, thank
It's
you,
a
sir.
developing,
And
it's a
sir, what
developing area.
happens?
Matters are pending. It's a developing area. There are
Okay.
high court judgments in favor of this.
Yes.
Yeah.
So, what happens if a party refuses to participate in arbitration proceedings?
Ex parte order can be passed if everything is correct.
Thank you, sir.
Because you are a defendant, you need to bring the evidence to disprove. If you don't participate, whatever the claimant submits, arbitral award will be passed based on that. If it's unambiguous, tomorrow he should not bring a case saying that no notice was given, the clause itself was invalid, it's a unilateral appointment to arbitrator. All the things are different question. As long as everything is fine, award, ex parte award will be binding.
Understood, sir. Thank you, sir.
So two of my colleagues had helped me. Usha and Meghna had helped me preparing the presentation. They are also there in this thing. I thank them for the support for preparing. Any questions are there?
Any more question from the students? Yes, Raj, you can.
Hello.
Yeah. Hi.
Hi. Good afternoon, Mr. Abraham. How are you doing today? You made a passing reference the steps the government is taking in that direction. But then, how long before we become a global hub for arbitration, and that the government?
To be frank, yeah, you're done with the question. Anything else?
Yes, sir. Go ahead, please.
No. So, frank answer. It's a long way to go. If you can hear there's a ONGC chairman statement on arbitration. This thing it's in a recent this thing when the Minister for Law and Justice was sitting, he was making the statement. So one line answer is a long way for us to reach there. Lot of structural reforms are required. Our judiciary, like we need to have a streamline, because supervision will be High Court and Supreme Court. That supervision cannot be changed. So when the supervision is by High Court and Supreme Court, unless they are declogged, separate benches, consistency, precedents are not followed, there is difficulty.
And what's the reason behind this inertia, sir? Why is this lethargy?
So,
why inertia?
So there are so many things, like why bullet train is not there in India, why this thing. So it's like government is working on multiple things. Like Today, priority for the government is employment. Today, priority for the government is basic infrastructure. Litigation, etc., are side, it's impacting our ease of doing business, World Bank ranking, it is impacting, no doubt. But they are not the priority. Priority is education, priority is employment, priority is infrastructure. Once the Make in India, employment, etc., generated, automatically all this thing. Yes, it can be argued cases, our delay in arbitration, enforcement of contract, etc., are the reasons why we don't get investment. We are fine. We are happy with those investment coming with remaining that. So when the prior government, it becomes a priority for the government to take the reform. At that time, they will do. Nidhi Aayog, etc., has been tasked with this thing, but it requires not just the policy statement. It requires a lot of structural change, like ease of doing business or digital India has been Make in India. We have been doing the sloganeering for last 10 years. But transition is happening now. Like mobile phone, after so much period, today we have value addition of mobile phone or Make in India from zero net importer to we have become net exporter. For pharma, we are today dependent on China. But 30% APA was we were able to do Make in India. But it is slow process. Priority things we are focusing. Slowly it will be taken up. Inertia, like bandwidth is the issue for everyone. Governance team also has the bandwidth issues. I'm not a right person to comment on why inertia is there, but I'm just my light on it.
And as future lawyers, sir, how we should um, go ahead and make sure that things happen or move ahead in the right direction? What should we do to ensure that?
We should not be concerned with the delay. We should be concerned with the brief in our hand. We should try to do justice to the brief in our hand. First priority is the clear disclosure to the client about the timeline. No promises that this matter will be settled in 6 months. Reality, tell the client, make him understand on the day one, it is going to take time. It's a slow process. I will be with you. Trust me, we will be in this journey together to reach this thing. Every step as a lawyer you take is important to succeed in the matter. Whether to move the application, whether to file an appeal, what evidence to lead, etc. It's a slow process. That is the like we should not be the one who taking the adjournment, which at the cost of our client. We should be always ready to do our matter on the day if the matter is called out. Yes, cost list, 20 matters are listed, only 3 matters are taken up. That is not in our hand. But called out, we take a time. Judges are happy to give time. Tariq pe tariq. Judges have no problem. But we should not be reason to for the tariq pe tariq.
Okay. Thank you, sir. Thank you for your time.
So there is one question in the chat box by RN Gaikwad. Can a court fix specific period for arbitration process?
By law, it has been fixed now. After 2015 and 19 amendments, the law itself provides 12 years for finishing 12 months, 12 months for finishing end-to-end arbitration procedure from the appointment of arbitrator and concluding the pleading. So that will reduce the thing. But what will be the challenge? There's a time before appointment arbitrator going to the court. There they are trying to fix it by 6 months. The 6-month court need to, like Delhi and all, within 2 months arbitrator is appointed. Maximum is 2 months. Usually in 7 days, filing an arbitration petition, arbitrator is appointed 7 days to 15 days in Delhi. But some other high courts are difficult. But appointment maximum 6 months, Supreme Court. Then 12 months, like you complete the pleading, you are fast enough to complete 6 months. And the 12 months, 2 years, you can do end-to-end getting the award. After getting the award, the party agreed, will like to try first appeal, then try review, then file SLP, then try curative. So this 5 steps every party is going to take, whoever can afford a senior advocate to do, is going to delay the process. It's not on the hands of the court or the judge at then. So as an advocate, we also should in a position to tell this is the like it's a fair judgment. It's a time, shake the hands and move. But problem is that once you get into litigation, we'll say that nothing is fair. Always there's a hope to reduce that demand.
Thank you, sir. So there is one question that what are the most common drafting mistakes you have seen in arbitral clauses?
like uh, trying to keeping it simple, missing out on governing law, missing out on number of arbitrators, etc. are the this thing. Like within India, these mistakes does not matter. We like dispute all the dispute by arbitration. Fine, but having a institute, having the process specified will be better. So like I tried to take you through, give you a flavor of types of case laws ended up. All these cases are ended up because there was some drafting error. These are the things which you try to keep it. Institutional arbitration, having a simple clause, process, due process of all these errors are taken care.
Thank you, sir.
Sir, can an arbitrator be replaced once appointed?
There's a process for replacement, etc., but it's a difficult process. Like unless there's a bias, unless he has worked, etc. Like you are appointed, you have to go to High Court to change it. Or otherwise, Suomoto arbitrator says, I disagree, I do. Or the conduct of the arbitrator is biased. Supreme Court has passed the recent orders removing the arbitrator appointed by Supreme Court itself because conduct, there was bias was alleged in the way conduct of the arbitration was done.
Understood, sir. Thank you.
Party autonomy is there, but due process, natural justice, principles of natural justice, equality, Article 14, etc., need to be followed throughout the process.
Sir, I have one question. Is there any rule for claim amount for which we can go for arbitration?
No.
So means if I have a claim amount of let's say 1 lakh or 2 lakh, shall I go for arbitration? Because maybe arbitration cost may be much more higher than what I'm going to claim it, right?
That is the difference. If you look at the NSC, National Stock Exchange matters, etc., like we are represented few of them, and they're like NSC is charging 100 rupees. Option 4 is nothing but arbitration.
Oh, okay.
But once it is provided, it's costly, no option.
So means it will be enforced to the party or how it is?
No, if you want to make a claim, so
okay,
like you want to make a claim, you have to go by arbitration. They will impose the penalty and they will recover. Like end of the day, who will is the plaintiff, who is the respondent?
Okay.
As long as you are a respondent, good in this country, you don't need to worry. As long as you are a petitioner, you need to worry in this country.
Okay. Sir, there is one more question. When we talk about the fast tracking in the arbitration process, so what that mean exactly? Means if there are 10 processes or 10 steps in the arbitration process, out of that 4, maybe we will consider 6 we can be way off, or maybe.
No, so we cannot do any of the process has been set considering due process. Tomorrow, any of the steps have been waived. Supreme Court will say patent illegality, natural justice not followed. This thing, like you make a claim, so time is given for the other side to have a look at it, make a counter claim, produce evidence, both the sides inspect. All these are part of due process to come to the conclusion. It's being a quasi judicial, it's faster, etc. But none of the steps can be taken away. If they get it can have a errors apparent on the record or patent illegality, miscarriage of justice, anything can be called to question those kind of orders.
Okay. Thank you, sir. Yeah.
I have an appended question to one earlier you actually answered, sir. If you don't mind, can I ask?
Yeah.
Sir, you actually told about one of the question you actually told about replacement in the midway of a arbitrator. What if the case is about involving our international? For example, the case of Byju's, where the investors were actually international. If the replacement has to happen, you actually said it has to go to the courts, mainly High Court or Supreme Court. In the case of such a kind of a case of Byju's, which jurisdiction actually gets applied? Is it international or is it Indian? Because one of the parties is Indian now.
No. So one of the parties is Indian. First question in this situation, ask her what is the seat. So seat is say New Delhi. Automatically Delhi High Court will have all the jurisdiction. Seat is say Singapore or this thing. Automatically Singapore courts as seat is say New York. So seat decides all this procedural conduct of the arbitration. After having a seat, governing law can be different. So procedural conduct of the arbitration will be dictated by the seat. Supervision support role. Supervision and support role provided by the court will be based on the seat of the.
Thank you, sir.
Sir, are there any books you would like to recommend which every lawyer must read?
Frankly, like bare acts are good enough. Reading the case law is the this thing. Like you have a bare idea about what is the this thing. Like any basic test, like Junjunwala, etc. If you read SM Junjunwala arbitration, Snow White, that gives you good flavor. But after that, to do the matter, case law, reading case law is very, very important. To get the basic understanding, concept clear, commentary will help. But every day, nurturing the knowledge can be done happening through only reading the case law. It need not be arbitration, any other contract, etc. Because those principles are applicable.
Thank you, sir.
Sir, just to add to that, law by book is different and law by usage is different. Any suggestions of any good website, blogs, or podcasts to be following for the law by usage?
Sorry, I didn't get the question.
The law by book is different from the law by usage. Just to add upon your the Bear Act, this one, any suggestions you have for us to follow good website, blogs, or podcasts to
No,
follow for the
I'll
law?
come. So, my preference or my suggestion or advice to all this thing is that blog, podcast, YouTube videos, etc. Good to understand basic thing. You should not make a conclusion or inference from reading the article or this thing. You yourself should go and read the judgment. Because when you rely upon, like it's like you rely upon the head note to see the this is a judgment to make a conclusion. Because head note is a interpretation by a third party. He can make his own biases, etc., to come to a conclusion. It's always better to go to the judgment. So when you read the judgment, it's multiple things happen. You see how one party is putting an argument, articulating. How when you read the petition argument, you feel that you will convinced petition is going to win the case. Now then respondent will come and argue. Then how the judge balances out both to come to a conclusion. Then you understand like what niceties judge has picked up from both the sides to say this argument against that. Both the parties are argued in the rejoinder and this thing say that why they are right. So nothing better than podcast, etc. You're traveling, you want to just to understand this thing. Good. You have to just get a summary of what is the case. But reading the nothing cannot replace reading the case law.
Thank you, sir.
So there is one more question. How we are going to attract more and more people towards arbitration? That means, like our Honorable PM has also mentioned, we have to make India as a arbitration hub, and more cases should come through arbitration. Then what could be the major or what actions we need to take? Because first, initially, I can see it's very it's not a cost effective this one if you go for arbitration. If we want to make it cost effective, then what measures we need to take so that people can more and more can attract on the arbitration side?
Why arbitration is not cost effective? Like we are comparing the Indian scenario. Outside India, arbitration is much cost effective to compare it to doing a trial. I want to do a trial in US or UK. Cost of trial is significant than doing arbitration. When it comes to arbitration in India, we compare with the court. In the court, our advocates, like I'm not blaming our fraternity, but I'm saying as advocates, they are happy to do and take low cost and take tarik pe tarik to get their fees. So like it's a quality versus the quantity, mismatch between demand and supply. That is the reason why court people are ready to do at much lower fees. But actually, when you end up doing a matter in the court in India, cost is almost similar to arbitration. There's not much difference. Only fees part of the arbitrator comes as an additional cost, which Indian taxpayer subsidizes when the salary is paid to the judges. That is the difference. Other than that, cost part is because judges' salary, etc., are capped. That is the reason. Like if they sit as arbitrator, they can earn much more than what they earn sitting on the bar, other side of the bar. So, remedy solution: what to make it fast? Cost is not a comparable. There are different reasons not to compare the cost. Timely remedy is the speed at which, like, you start and you are able to do matter in 2 years, end to end, finality, get the payment in 2 years. It will succeed. People will left, right, go for arbitration. Automatically, cost will come down. Today, high stake construction matters of PSUs, NHA, etc. goes. Otherwise, people don't go.
Sir,
One I just want to suggest is that, like, government, one more efforts is that promote mediation, conciliation. So mediation as this thing, government is trying that, like, don't get into the arbitration itself. At little before itself, can we shake the hands and finish the matter? But there also we are facing the challenges of we don't have qualified mediators who can discuss with both the parties and come out with a solution which we can solve it. Once I am appointed as given a wakalat and a brief, I will argue for my client only. However the bad the case, I will find ways to say that I am right. So mediator need to step in to say that what you're saying is bullshit. Supreme Court decisions are against you. Put a full stop. We lack that today.
Okay, but sir, because the claim amount is higher side, then I think arbitration cost, whatever is
So
there,
today,
may be negligible in that sense.
no,
But
no, today,
wherever
no. So today in the scenario, cost was this thing, claim amounts less than 50 crore. It's then not a win-win. Anything above 50 crore, it's a win-win situation only. Less than 50 crore, 50 crore to 10 crore, it become dicey. Should we go? Should we not? Less than 10 crore, claim amount was the cost to be 30%. Cost will be 30% of the claim amount.
Okay. Okay. Got it. Thank you.
Hello, Sir Raj here again. Hello.
Yeah. We'll take this as the last question.
Yeah, so considering that there's a significant dearth of qualified arbitrators, should the law schools consider that they should run courses, specific courses for arbitrators? And should we include that as a part of our curriculum?
So that's the one error I see in arbitration.
To alleviate the burden on the judicial system.
Hello?
To alleviate the burden on the judicial system, should they?
Yeah. So in India, judiciary feels only the lawyers or the judiciary can be the arbitrator. Outside India, they feel that technical experts are the correct person to arbitrate the matter to decide. They understand. DMRC matter, 3 engineers concluded technically this is wrong. There is a construction defect on the DMRC on the way bearing and the load capacity. But judge said that the way you written the award is incorrect. So it's not about lawyer being a better arbitrator. Lawyer can articulate. Lawyer can guide an engineer to articulate what their thought process is. A mix of arbitrator tribunal with a judicial member being from the lawyer and a technical member from the field is this thing. But our arbitration mostly we tend to give judicial members who are not aware about the technicalities of the project, timelines of the project, etc. That creates this thing. Training in the school, college, like training, it's not now after the 2015, it's not about the arbitral award. Its problem is the post-arbitral stage is the challenge. After the award, people litigating is the challenge on the litigation. Can you stop it? You cannot say that arbitration full and final, no one cannot. You cannot take away the powers of 226, 32 supervisory powers of the judiciary and curative powers provided under Article 141, etc. to the courts. That is going to remain. So, college having a courses, etc. can help in formulating this thing. Exactly the reason why college is organizing this to give this thing, because there are a lot of difference when you practice versus theoretical knowledge. So it comes out the period this thing. So I will not say that course will make you this thing, but definitely course will make you a better person to deal the matter.
Okay, thank you, sir. I think so. The session was quite igniting one. And I would like your colleagues, as you mentioned, Tushar and Meghna, to just on their cameras.
Krusha and Meghna.
Okay, Krusha and Meghna, please can you just on your cameras?
Yeah. Hi. I have some camera issue going on, but it was a great session. I think it went very well, and the students were very inquisitive. It is very good seeing all this.
Okay, just I wanted to just make an acknowledgement that, sir, your wonderful words and the writers behind your words. So thank you to all three of you for such an igniting and wonderful session. And I would also thank you for justifying the topic Dwarpal, the arbitrators, the gatekeepers of justice, who decides what. So this intense discussion would have from this intense discussion, I could just conclude that arbitration is not the future, but it is the present of the judicial system, the alternative dispute resolution system. Because we always say that arbitration is the future, but I think so we can draw a line that it's not the future, it is the present, and hence these things are going on. So I would like all the participants to please on your cameras for a photo, for a snapshot. All the participants. So that we can have photos. The coordinators, student coordinators can help with the photos.
Sure, sir.
Yeah. Okay.
Yes.
Okay. Thank you. So the takeaway of the lecture, I can say that to have the bare knowledge of any law, even arbitration, as sir has rightly suggested, read the bare act first. So we can take this as a takeaway of today's session. And I would now like our student Priyanshi and Ansh to take over the session for formal vote of thanks.
Thank you so much, sir. To justify the name Dwarpal, we have a shlok. द्वारं द्वारं प्रति हि ज्ञानं दीपवत् प्रज्वलिति यः पश्यति स पश्येत् यः न पश्यति स न पश्येत्. At every gate, knowledge shines like a lamp. He who seeks it perceives it, he who ignores misses it. With this thought in mind, we bring a close to today's session on Dwarpal. The metaphor of the gatekeeper has guided us to reflect on who decides what in arbitration and how this power of decision making shapes the very path of justice. May the wisdom we have received today remain with us like a light at the threshold, guiding our further understandings.
First of all, I would like to convey a heartfelt thank and gratitude to our learned speaker for his valuable insights, as well as Krusha ma'am and Meghna ma'am for their unwavering support, as sir mentioned. Thank you, ma'am. Uh, Really, sir, this session was very informative. Your well-structured method of teaching helped us learn and retain what was taught in today's session. I would like to thank our participants for their engagement as well. I hope that this was a very one-on-one session for you, sir, as you asked me yesterday, and the organizing team for their efforts as well. With this, we conclude our day 2, carrying forward the flame of learning into the days ahead. Thank you so much.
Thank you.
Thank you, sir. Thank you.
Thank you, sir.